Okay, welcome everyone to this panel. Thanks for joining us, Roger. My name is Simone van der Hof. I'm a professor of law and digital technologies at the eLaw department, and I'm very happy to chair this first panel that we have today. The goal of the panel is to continue the conversation. So we had some very interesting and inspiring conversation starters from Roger that I believe with the panelists that we have will bring us to a lot of very interesting further conversations given the projects that you're working on. And let me first introduce the three great panelists that we have. Here on the left next to Roger is Elettra Bietti, and she is an assistant professor of law and computer science at the Northeastern University in the United States. Then next to her we have Paul Nemitz, who is a principal advisor to the European Commission's Directorate General on Justice and Consumers, and also a visiting professor at the European Legal Studies Department of the College of Europe. And then next to Paul we have Lynette Taylor, who is a professor of international data governance, I should say. To me, it always sounds somewhere between government and governance, but governance at the Tilburg University, Tilburg Institute for Law, Technology and Society. So, Lynette, now I've come to you. I would like to start with you to continue or to start the conversation based on the conversation starters that Roger has given us. And I would like you to reflect on technology as a governance project, and maybe particularly, but please change the direction if you want to, maybe particularly also focus on the challenges that platformization has for society. So the floor is yours.
Thank you so much, Simone, and thank you, Roger, for a really, I'm honestly saying this, inspiring talk. It was very, very helpful, very illuminating, and I'll be thinking about it for a while, so thank you. I'd like to pick up on one of the sources of discontent with the law, which you may or may not agree with, I don't know, and that is the entrepreneurial capture of public goods by what we broadly term platforms, but often are not. They're often providers of data analytics services or providers of computational infrastructures. These things are blended now, but we tend to still use the terminology of platforms for them, and I think it may be time that we rethink that terminology a little bit. I'm thinking of issues like the entrepreneurial capture of public healthcare data in the UK by Palantir and specifically by Amazon originally during the pandemic. Google's attempted capture of the education sphere and of the student data from most of Europe and the US and now globally. Facebook's influence over electoral politics, the same could be said for Twitter. Palantir's attempts to capture welfare provision around the world and humanitarian provision. Google's attempts to capture public transport through payment platforms. All of these things involve the infrastructuring of the public sphere. They involve the infrastructuring of public goods. Am I not audible? Sorry. They involve the infrastructuring of public goods. They involve purposeful economic and technological capture of these public goods. But we're not seeing them very clearly. What we're seeing them as is an old story, that of privatization, and they tend to be referred to as public-private partnerships. But what all of these movements, what all of these shifts have in common is that they're not partnerships. They are the entrepreneurial capture of public goods through venture capital invested in infrastructure over a long period of time, and specifically through infrastructures such as data centers, the infrastructures which materially provide connectivity to us, and the computational databases which lie on top of those physical infrastructures. And increasingly, those who invest enough in infrastructures own our public services. Why is this a problem for the law? Why is the law having trouble with this? I think it's sort of an epistemological problem that is built into law and regulation of technology. And I'm very interested in solving that problem. That is the principal thing that I work on at the moment. We're sort of stuck in various paradigms which don't work for addressing this. One is the paradigm of user consent, the notion that we are users of entrepreneurially provided services when those services are, for one thing, inescapable, so we're not voluntary users. The idea that we are consumers of those services when in fact we are performing labor for them by engaging with them. We are performing productive labor for them. And the notion that we have any kind of control and autonomy with regard to those service provisions. We don't have the capacity to disengage with them. We don't have the capacity to change service providers. And the way that we're discussing them, I would say, also distracts from precisely the problems of political legitimacy, which were roiling under the surface of everything Roger was just describing, I think. For me, the best example of this is possibly Amazon's capture of NHS data, so that during the pandemic, the logic for this was that during the pandemic, information from UK health research, so come out of Alexa speakers in the UK, when these speakers were asked questions by UK buyers of these speakers, as opposed to US information. So that is overall a very commendable enterprise. But what it meant was that this gigantic database of public health research, which was paid for with our taxpayer pounds in the UK, wound up in the coffers of Amazon and could be used under the contract it had with the UK government for any commercial purpose whatsoever in perpetuity. So Amazon gets to build its business, its pharma business now, based on UK healthcare data. The legal problem is summed up by the fact that when this was challenged by public litigators, the UK government responded that this was not a data protection problem because no personal data was being transferred. And therefore, I think the quote is, the public interest in this contract is non-existent. The public interest in our health data is the only interest in play there. But the government was able to distract us with talk of data protection. If that hadn't worked, it would have talked about competition or consumer law, I'm guessing. And so the law is providing a shield for these takeovers of the public sphere in ways which should make all of us very uncomfortable, but which increasingly we buy into because that's where we get our money from. That is problematic for us as researchers. We are involved in legitimizing infrastructural power by responding to it only partially through particular legal framings, which don't address political legitimacy. So this is a problem of public governance, I would say, which includes problems of law and regulation, and of moving beyond the framing of public-private partnerships, which comes to us through decades of managerialism, through decades of collaboration between what I would term policy disciplines, such as PPE in the UK, or public administration and law here in continental Europe, which treats these ultimately as problems of channeling data appropriately within an individual rights framing. And I'm not disrespecting the individual rights framing, I'm disrespecting only the co-option of that framing as a way of dealing with problems of the political legitimacy of large-scale capture of public goods. So law's interaction with the policy disciplines, I think, is problematic in relation to this, and also the notion of an innovation-promoting framework, which ultimately also, like the risk-based approach in the AI Act, in the GDPR, winds up legitimizing this form of capture. What we need here, I would say, is a responsibilization of government for protecting those public goods, which is ultimately a political and electoral enterprise. And here's what sort of the question I want to pose to Roger is, where does the political and sort of electoral enterprise fit with what you've been talking about? We also need to be able to conceptualize publicness as something other than an economic category. And people have pushed back on this logic for a while, since I've been saying this for a few years, with the notion that a public good is not what I think it is. And yet I think when I describe these forms of capture, it's quite intuitive what a public good is. It's something which affects the integrity of the public sphere and which is involved in creating public value, i.e. non-economic forms of value. And so the ability to deal with these forms of capture and these forms of value is something that I would encourage us as disciplines to start working on a little more closely. Thank you very much.
Roger.
Oh.
I would love to give this one to you. Please,
okay.
If you want to respond.
Well, I'll just respond very briefly, if I may, Lynette. Yeah, I mean, I remarked in passing that I think initially, in the early stages of technological development, you will often find people who claim they've been harmed by the application of technology will raise the issue in a court. I mean, often it'll be an easy case to hang on some kind of tort peg, but it might be quite difficult, might require some creative work to find a basis for the claim. But essentially, you're looking to the judges and the courts to resolve this dispute. And the judges will find themselves then at least in some jurisdictions, like in the UK, I think in Europe as well, in an awkward situation because they're being asked to make the kind of decision that they're not really mandated to make. They don't have the resources to make. They can't involve themselves in public engagement in the way that the politicians can before they decide which of the various stakeholders are to be prioritized. And so you find, I think that there's a movement across, we shift the responsibility from the courts to the political branch. Now, whether we do any better having done that, I don't know, because as Lynette was, I think, indicating here, there are limits to what you can achieve through the political branch as well. And ironically, some of the most progressive decisions seem to have been made by courts, landmark decisions, pushing the boundaries in ways that politicians would not be prepared to. But I don't know that. I mean, I've had conversations with Hans Thompson about this quite a bit. We have judicial institutions, we have political institutions, and we have NGOs. But I mean, mainly we're relying on judicial and political institutions to do the governance work for us, public governance work. And I wonder whether these legacy institutions are appropriate at all, actually, in whether we need to, I mean, I don't know what the new institutional framework looks like, but do we need a new institutional setup? Because again, these distinctions that you rightly say, Lynette, between public, private, I'm not sure that's the way we should be trying to break down the world anyway. Although I do think, and this gets to the nub of it really, I skipped over those slides where I was talking about the governance matrix. But one of the points I was going to make there was that when you get the full span of governance in view, and even if you're thinking in an old-fashioned way about public governance, public-private partnerships and private governance, all our attention seems to go to public governance. It's all focused on that. Oh, there's a little bit about what about private governance, self-governance? And by the big tech companies, this is where the real action's going on. You know, while we're waiting for public governance to take a position on something like ChatGPT, private governance has to try to take care of it in various sorts of ways. You know, we can't wait. Self-governance isn't a license to do what you want. Self-governance has to be reined in by, well, I don't think the rule of law will cut it, because the minimal version of the rule of law says you have to have rules, you have to govern by rules, commit to rules. That does impose some constraints, but unless you're going to gloss that with substantive requirements, it doesn't constrain that much. And good governance has the virtue, I think, that good governance applies equally to public and private governance. And so, however you cut that cake up, there are standards that have to be met. You can't just slide out of the rule of law or human rights commitments by saying, oh, this is the private sphere. Yeah.
I might get back to you, Lynette. Paul, I would like to go on to you, and I believe you want to make some points on the legitimacy of governance, and particularly also alternative modes of regulation, to get back to that term, because it's the more sort of the term that we still more use than maybe governance, but that's something we need to start thinking about. So alternative modes of regulation, and then I mean modes of regulation other than the law. So would you like to continue the conversation with Roger in that direction or any other direction if you got inspired by the lecture to raise another issue.
Thank you very much. I must say I'm very inspired by Roger's presentation. And I think what we need is a common starting point in this plurality of ideas in our society, where we all more or less can converge. And I think Roger has grabbed very high up in the level of abstraction and used the governance as the common starting point. And indeed, I think in particular in international law, you know, if you think about what could the UN, for example, do on AI, if you go too specific, we will not find agreements, but there is a global interest of dictatorships and democracies to maintain governance of states, for example. So I think this parameter or this notion of governance, very high level of abstraction, I think has a function and can work, in particular in the international law context if we think about future rules for technology. But it is a notion which applies also to dictatorships. Dictatorships have a governance. And I think this is where my doubts come in. It's a very high level of abstraction. It would also encompass any type of private and technological governance, you know, as unfair and as illegitimate as it may be. So that's why I would say the point of common convergence in this world of plurality and diversity of views must be more concrete. One level down of concreteness is probably the rule of law. We can have a rule of law, we had it in Prussia, without democracy. And here the discussion of the alternative starts. Rule of law, and we can already differentiate, as you just did, rule of law. Well, is it law which is made by private parties, you know, the community rules of the big platforms, or is it law which is made in public context? And here probably also the rule of law versus the rule of technology, because as I said, we can have rule of law without democracy, China. We can also have a rule of technology, which is, if it's only by technology companies, not democratically legitimized. For me, an interesting starting point, but still, given our constitutional settlement, too high up in the hierarchy, let's say, of abstraction. I would still go down one point further and say our common starting point must be democracy. I think you say we must maintain the conditions for people living together and so on. Yes, 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 all fine. But I think it is important because we have a constitutional settlement here, and you know, we probably can all agree that, you know, democracy is a bad form of government, but there's nothing better than that. So if we have arrived at this consensus, I think that would also be my answer to your question, which you said, you know, lawyers have to ask themselves, you know, how do we frame our interest in law and technology? I frame my interest, and I think this is also the interest, you know, which the Commission pursues, in making rules which ensure that in the age of artificial intelligence, or for that matter any other technologies you meant, our basic constitutional settlements of democracy and fundamental rights and rule of law, the trias, are maintained and functioning. And now we come to the question of the relationship of this starting point with technology and the options which we have, as you also outlined, and as Gianluca outlined at the beginning, you know, technology or governance, technology and law, technology versus law. I think if you look at EU law, you will find that slowly, and without making this explicit, we are developing a thinking of substitution relationships or hand-in-hand relationships of technology and law. What do I mean by that? The starting point being that the law is the most noble speaking act of democracy, and it is our instrument of choice. But of course, in the democratic process, here and there, And sometimes through law, decisions are made to hand over certain elements of governance and problem solving in very specific contexts. And the one discussion which just took place was on environmental sovereignty to technology. And I think this is the most important and most interesting area of work, namely a new science of substitution relationships on the one hand, and of a coherence relationship and a mutual strengthening relationship between technology and the law. I think much of the problem solving in the modern world, and by the way, I would share some parts of your criticism, but not all of them, because of course, you know, when it is about innovation, let's say in the research sector, if we would constrain innovation only to the public sector, the health system would have huge problems. So I think it is smart to enlist private parties also on a large scale in this exercise to drive forward innovation. But the question is, who decides how to enlist and for what purposes? And I think here, you know, sort of in a little bit more a specific, precise formulation than done by Shoshana Zuboff, for example, in her book on surveillance capitalism, where she said the key question of the future is who decides who decides. I would say it is key that it is democracy which decides in which areas we can leave governance to technology, or we can enlist tools of technology to solve governance problems, and in which other areas we may even leave it partially to self-regulation or ethics, and in which other areas we say, no, we need parliamentary law, or for that matter, delegated regulation, meaning non-parliamentary law, which comes from a lower level. And we have to be a little bit careful with the word of regulation, because in the US, I would say much of the regulatory process is actually not very democratic. It's a crutch for a political system which is not able anymore to do parliamentary law. This whole system of regulatory bodies, in Europe, on the other hand, regulation is a term of the treaty, and a regulation is actually a law, a parliamentary law. And in this debate about, where is the place of legitimacy to decide for specific issues on the specific relationship between law, other modes of governance, technology, ethics, self-regulation, and so on, we must also be very careful, I would say, and jurisprudence in the European Union at least forces us to be very careful, that whenever a political discretion is exercised in answering these questions, and very often this is important political discretion, because leaving it to technology means leaving it to concentrated power, and we know all the problems this is, that these exercises of political discretions remain in the hand of parliaments and not governments, not the executive. And so I think if we approach it from this way, if we ask our question, if we take as a common starting point the paradigm of democracy, I think many of the conundrums which you address can be solved. And I would say the good news is that with all the failings and all the imperfections, in Europe, this parameter of democracy still really in practice can be applied, and we have seen it in the last mandate. We have produced a lot of good laws, and these are not fantasies of bureaucrats. These are laws which are approved by the governments of the member states of the European Union and by the people in the parliament. And the parliament has played an important role in inserting, and you mentioned here and there some examples, and there are many more, inserting elements of, for example, higher levels of fundamental rights protection, but really also in a finding process, because many of these laws were cutting edge, addressing cutting edge new challenges, just new innovative concepts. I think we can be quite proud about this element of societal innovation. So this would be my last thought to share with you, and that's why I think conferences like this are so important. We often talk about the innovative society and the importance of being innovative for purpose of competitiveness and so on. And this is, of course, EU policy, which we pursue. We want a society which is innovative technologically in business models and competitiveness. But we also need innovation in the areas of democracy and in the area of rulemaking. And I would say preferably by parliamentary law. And I think we can be quite proud about our achievements, in particular in the last mandate. As imperfect as the Digital Services Act, the Digital Markets Act, the Data Act, Data Governance Act, AI Act may be, and previously also the copyright reform and GDPR. This is, in the end, really a huge balance, a positive balance of innovation. It is not true that these laws hinder innovation. No, they direct innovation in a direction which is wanted by democracy. And it's a little bit the same process which we went through in the 80s and 90s with environmental law. It is just a different type of innovation which we are bringing forward. And I would say in the midterm, like environmental law, the greening of industries was a huge competitive advantage for Europe. These laws will also become a competitive advantage in the age of AI in comparison to the rather unregulated situation in the United States. And let's not make a mistake. If we talk about the crisis of democracy, the attacks on democracy from the outside, from Russia, and from inside, from populists and right-wing ex-fascists and neo-Nazis and so on. If we want to do something about democracy, we cannot continue to talk down the law as this is the most noble speaking act of democracy. We must show that democracies can deliver, and I think Europe has to come to terms with the fact that with or without Trump in the United States, America is not the country which is leading in, let's say, democratically addressing the challenges which we are discussing here. Because if a nation is not able anymore to make laws, parliamentary laws, which address which part of the issue shall be addressed through rules, which part of the issue shall be solved through technology, the leadership on democracy is lost. And so I would say for the next European Commission, certainly maintaining democratic governance of technology will be very high on the agenda. We will be working very much, for example, on strengthening the fourth estate in democracy, journalism, which is so much suffering from the new technological and business model environment. And I think we will also walk with a head held a little bit higher than in the last mandate on our ability to make innovative laws which address the challenges which technology pose for our society and for the future. Thank you very much.
Thank you, Paul. Paul was giving you some prospects. What do you think, Georgia?
Oh, well, thanks, Paul. You know, we come from the same page, I think, of course, in voting for democracy and thinking, I mean, my ideal of good governance includes the idea that those who govern should govern in the interests of those who are governed. And although, of course, this might suggest it could be authoritarian and paternalistic in some circumstances, the usual way of doing it would be to consult with those who are governed to see what their preferences and priorities are. And I think that, governance, as I conceive of it, is not just at the nation-state level or the international level, but also the micro level. It's everywhere. I mean, you know, whether you're talking about sporting associations, you know, clubs. I mean, governance is everywhere, even in families. Good governance, I think, in small groups can really do quite well with democracy. But the more you scale it up, the more challenging it becomes, and the more people sense that they're detached from where the decisions really are made. And of course, democracy has a price, that the more intensive the consultation, the slower it is to make decisions. The more, you encourage people to have a voice. And in pluralistic communities, those voices don't all speak the same. So, you're brewing some discontent there. But nevertheless, I think democracy is the way we should be trying to do this. I absolutely agree. And the outcome of this will be that I think there will be a plurality of communities that commit more or less to technologies alongside the law. I don't see every community thinking we must invest in technology in the way that others will. There will be an East Coast and a West Coast style of governance, But the one thing that I think is non-negotiable and not subject to democracy and pluralistic preference is, again, the foundational conditions. I don't think we can have any kind of negotiation on that. And if that takes an authoritarian kind of rule, well, for the sake of saving the planet and saving humanity, then that's what it has to be. But I would draw the line at protecting those foundational conditions.
Thank you. Elettra, you're working on a project on technological capture. We've already started the conversation a little bit about that, also with Lynette's response or addition to the conversation. Would you like to take that further here?
Yeah, sure. So first of all, I just wanted to say thank you so much to Gian Claudio for the invitation. It's a pleasure to be in Europe among European colleagues in this beautiful room. So it's very nice to be here. I'll be the American in the room with the laptop because I ran out of paper. So one thing, I guess I agree and disagree with bits and pieces that I've heard throughout the last 2 hours. I'm not going to nitpick on various pieces. But kind of as a broad reflection or response to what I've heard, and also to the kind of title and name of the conference, Law and or versus Technology. I think that sometimes scholars like us tend to focus on technology as a sort of abstract thing that sits out there. And a lot of my work has been, instead of thinking about technology as part of the market. So instead of saying technology, I say digital markets, right? And so the market is really the context both of technology and of law. And so in that sense, I think the elephant in the room, in the room during perhaps the keynote and perhaps also related to some of the remarks that have been made, is the question of how the market reacts or relates to democracy, to liberal, neoliberal law, to the rule of law, right? This idea that privates, including private companies, have the right to do anything they want unless prohibited to do so. That is the rule of law. That is what we learned in law school. The language of rights as the currency of law. These are very much terms that are related to a certain ideal of what private actors are in a democracy. And I think technology, but also the more broader neoliberal era, are changing some of these notions. They're transforming the idea of law, the idea of rights, and what we as lawyers ought to do. So I guess I want to do two things. I could say a lot, but I'll try to keep it brief, and feel free to interrupt me if I'm going over. So the first thing is I want to situate this question of law and versus technology in a historical arc of the last 30 years and how law has interacted with technology during this time and how we might understand our task going forward. And then the second part is discussing this project that I have around technological capture, which is a sort of reframing of the idea of regulatory capture as kind of weaponized or as it manifests in digital markets, so going slightly beyond the classic George Stigler understanding of regulatory capture and thinking more about what happens when all this regulation appears and to what extent are tech actors actually benefiting from it, to what extent are tech actors actually influencing the shape of the law as we currently are proposing it, implementing it, imagining it. So regarding the historical trajectory, I think one way of framing the last 30 years is we moved from an internet of networks to an internet of platforms. The way that people talk about the internet of networks is often by association to this idea of lawlessness. So people like John Perry Barlow famously talked about the Declaration of Independence of cyberspace, the kind of libertarian, cyber utopian ideas attached to the internet of the early days of the 1990s. But we also see ideas of lawlessness in relatively recent scholarship. So Shoshana Zuboff's famous book also talks about lawlessness as one of the causes of the emergence of surveillance capitalists, right? There was not enough law, therefore Google, Facebook, and others have emerged as these kind of tech giants. And I think one way of perhaps questioning that lawlessness framing is to think about law as potentially also, as having the potential to be in retreat. So the idea of neoliberal law or law that is voluntarily intentionally minimalist is a way of understanding what happened in the last 30 years. So over the last 30 years, tech platforms have benefited from a bunch of immunities, safe harbors. They use things like free speech in the United States to protect themselves from various forms of regulation. And so it's not that law was absent, right? It's not that democracy was absent. It's that democracy was thinking of the market in a particular way. Democracy, even in Europe, democracy thinks of the market as a thing that needs to be left alone. We think of the interests of tech actors, at least for a long time, right? Over at least until the 2010s, including in Europe. We thought of big tech's interests as very aligned with the interests of the public, of consumers, and of citizens, right? And so the right way of regulating technology through democratic means was to step away and say, let them do whatever they need to do. That's innovative, that's great for the public, right? From the 2010s onwards, what has happened is we have started realizing that the interests of tech actors were not necessarily aligned with the interests of the public. And so that's when we moved to the internet of platforms. That's when we moved to a relatively more concentrated ecosystem. And that's when we realized that our faith as a democratic, perhaps, polity, as, both, the faith of states, but also the faith of citizens, the faith of consumers, and perhaps even of the economy as a whole, depends very much on what these tech actors are doing. And so then the question is, how do we reinvent our institutions? How do we reimagine law so that we can contrast this power, so that we can reassert our rights, our prerogatives as citizens in the 21st century? So I'm not going to say much about where we're going. I'll just say, there's a bunch of different approaches to how we should govern tech actors, from data protection to antitrust to, DMA, DSA, AI Act-like regulatory frameworks that are going to be discussed in future sessions. And, my broad answer to how we should think about the future is in experimental terms. I think we need to use all of the different regulatory governance tools and approaches we have. I think the idea of good governance is really helpful. And I do think that the problem we're facing is a relatively novel one, and we need to think about governing the market in new ways, perhaps more interventionist, perhaps more democratizing. So moving to technological capture, I'm gonna try and be very brief here, but broadly this is a response to kind of faith in the law, right? So I think many of us, at least in the technological space, have inhabited one of two camps. One camp is the kind of relatively deregulatory camp. We don't want the law to interfere with markets. That's one camp. The camp of self-regulation, the camp of, tech companies not wanting anyone to interfere with their AI capabilities, etc. And then there's another camp that's perhaps the camp that many of us have been inhabiting for a while, which is the camp of how do we devise regulation from the top down, right? We think about law in this very unidirectional way. The law comes from the ceiling, the sky, and kind of is imposed on the market, right? But what's interesting about the regulatory capture literature is that it raises these questions about how the market is actually shaping the types of law that we have. And so it's not just a one-way street, it's also a kind of circle, right? It's a sort of infinite loop where market actors shape the regulatory problems, the kinds of possibilities that law can tackle, and then law tries to tackle those problems. And so the way we've been thinking about this is trying to move away from the classic literature that focuses on revolving doors or lobbying, which are kind of brick and mortar problems that exist across various industries. And we've been thinking more about specifics of tech markets and tech actors. And in particular, we've been thinking along two directions. The first is informational power. The power over information is a way in which tech actors can influence regulation. First of all, we've all heard in the news and everywhere a lot of discussion about how social media platforms are taking over the channels of communication, the access to information, right? And we don't read newspapers as much, we follow our Twitter feed. And so that's one way, the very material control over the channels of communication that is important. They also have the power to withhold information, to opacify information, to prevent regulators from accessing certain information, the weaponization of intellectual property rights, trade secrecy, but also privacy rights. And so these are various informational strategies they use. And then there's the architectural power, the power to shape infrastructures. This goes in two different directions we've identified so far. This is a work in progress. But one is the power to design infrastructures in ways that facilitate or disfavor regulatory intervention. That also includes the power to change the architecture of a platform in response to regulatory attempts. So in the course of an investigation, a platform might actually change their interface so as to avoid fines, for example. But they also obviously design their interfaces in ways that capture the imagination so that regulators basically have to rely on the existing architectural, infrastructural constraints that they've put in place in order to, or as a baseline for, their regulatory interventions. And the second form of architectural power, which is a form of infrastructural power, is shaping markets, shaping the conditions of markets, shaping competition, and Amazon Marketplace is a good example of that. I'll just add two more little concepts. One is, there's a question about the interaction between, so first I'll just say, another form of power is epistemic power, and it's very related to both informational and architectural power, and it's the power to shape our imagination, the power to shape our attention and our attentional priorities, and that obviously influences the way that regulators think about what they should tackle, what will be palatable to the public. And secondly, the question of market power is related to all these different ways in which tech companies capture regulation. And so the neo-Brandeisians, for example, talk about economic power as related to political power. And so there's a sense in which, again, to just go back to this loop, there's a sense in which you need antitrust intervention, you need strong institutions that rein in the power of big tech, that hold them to account, so as to avoid forms of regulatory capture that will then affect regulation and political processes. And so, again, it is a loop.
Thank you. Thank you. A lot of food for thought and for the very inspiring. When you said Twitter feed, I didn't tell you, but my field is children's rights and digital technologies, and I was immediately thinking, oh, but most of those smaller users, internet users or platform users, are actually on TikTok, which is even raises a lot more further questions. But I would like to go to you again, Roger. Any thoughts?
Yeah, well, one thought is that I think the regulation of online content is probably one of the most challenging challenging things that we can try and deliver on, because in fact I was reading something very recently about the situation in Australia, where you have quite different regulators charged with recent responsibilities in relation to online content provoked by, you know, high profile incidents. But you know, on the one hand, if you try and keep faith with democracy, although protection of children might be a point of consensus, but you know, where do communities stand?
Depends on the kind of regulation.
Okay. Okay. So, yeah. Well, I thought maybe that was a place where maybe there would be a chance of consensus. But you know, if you're asking the question in a democratic group, a process, what do you think is wholly unreasonable content to have online, and what do you think is reasonable? You know, there won't be I don't think there'll be a clear preponderance of views on that, or a clear consensus. And then you've got, as you say, Electra, the complication of the market and the constant pressure from business for light touch regulation. I mean, markets do need some governance. They don't run themselves quite, but you know, the view that they should be left largely to through the invisible hand to distribute goods in the way that makes economic sense. Well, yeah, but they need some regulation. And there's a pushback, going to be a pushback against against what business, or you know, would regard as unfriendly kind of or burdensome regulation. And I mean, in Europe, I think the culture is stereotypical, but we do contrast European precautionary culture with the American more laissez-faire kind of, you know, after the event. And you can see, you know, I don't know. You can say, well, like, for example, Jonathan Zittrain says in his book on the internet, we wouldn't have got the internet developed so quickly if it had been subject to strong regulatory constraint and ex-ante approval. But what have we got? You know, in the long run, maybe that wasn't a blessing. On the other hand, you know, in Europe, we've been hit very badly by some scandals which we don't want repeated, and so we are understandably precautionary. Gosh, I don't know. I mean, I'm not suggesting governance is simple. I'm just coming along with, as Paul says, a very high-level idea of where we might start thinking about good governance. Yeah.
I need to wrap up. I would have loved to come back to each of the panelists, because I can see that there might have been some responses from you as well. I know you need to rush off, but I would like to wrap up with one small question before we. So I hope you can still stay a couple of minutes, Lynette. Otherwise, just rush out of the door, because we're celebrating 10 years Advanced Master Law in Digital Technologies, and given all that we have heard, it's a simple question. So please, just one sentence. What is an essential skill that we need to teach our students in this advanced master, given all that we've heard this morning? Lynette, I'm putting you on the spot, I know.
Thinking critically.
Very good one. And each of you needs to mention a different one, of course. Because we'll probably agree on all of these skills.
Yes.
So, Paul,
I think you need to equip your students with the ability to carry out impact assessments of new technology in relation to fundamental rights and democracy impact. And this applies, you know, either to informatics or engineering people, or to lawyers. So the engineers and informatics, they need to learn more about democracy, fundamental rights, rule of law, how does this work, and use their technological imagination to imagine potential impacts on this other system, while the lawyers need to learn to join the engineers in understanding the technological potentials and then apply their usual skills. I think that will be a key skill in the future, and I'm very hopeful you will be able to develop this like we have developed, for example, the engineer for environmental impact assessment.
I think we're already ticking 2 boxes. So, Elettra, what would be your skill?
So a lot of people say humanities in relation to technology, and I'll just add, recently I heard someone say that the practice of attention, basically what the humanities are, is that they train people to pay attention to difficult things. And so I think the practice of paying attention to things that are not just immediately demanding our attention is what I would teach, away from technology.
I think that's a very difficult one. I also noticed myself. So yes, but a very good one. Thank you. Roger.
Well, I don't necessarily think it's teaching them coding. I think we might be investing too much in digital technologies when other technologies, we don't have to teach people to be geneticists, for example. But I do think it's, and I'd say this more about undergraduate law programs and masters, but I do think, first of all, they've got to think outside the doctrinal box. They must think outside the box of doctrinal law. Which box? That might take you into another box, but, I think it's a bigger picture.
Pandora's box, maybe?
Maybe, yeah. But that's the first thing. Secondly, they must understand the significance of technology these days. And the third thing is to understand why governance and law potentially really do matter for all our prospects, for all our sakes.
Yes, thank you very much. To play well in a concert, you have to play your own instrument very well. So I think you also need to be an excellent lawyer, but I agree with all of the other skills that you've mentioned. I would thank you very much. I think we could go on and on with this panel and discussing more, but time's up, unfortunately. So thank you very much to each of the great panelists. And again, also thanks, Roger, for an excellent lecture, and thanks for joining us in the panel. So please...